Alright, we're on Grass Conservation, Kentucky. 500, Declaration Policy 353 through 500 to 720. Alright, 353, 500 Declaration Policy with the KRS 353, 500 to 372 is hereby declared to be public policy of the Commonwealth with the foster with the conservation of all mineral resources and encourage exploration of such resources to protect the correlative rights of the land and mineral owners to prohibit the waste of unnecessary surface law for the damage incurred with the maximum equivalent oil and gases from all the deposits that are now known, which may hereafter be discovered to promote safety with the operation of the end of the Kentucky Regulation Statute 353, 500 to 720 is enacted and shall be liberally construed to give it effect as such public policy. General Assembly found with the government responsible for regulating all aspects of the oil and gas exploration of the product development, gathering, and transmission rested with the state government. Department shall propagate relations thereto with take all the necessary to assure the efficient oil and gas operation, protect the property, health, and safety of the citizen in the Commonwealth in manner with the KRS Chapter 353 to exclusion of all of the non-state governmental entities except provided in Chapter 100. Department promulgated regulations relating to gathering lines 6 months after June 24, 2003. Nothing in this section construed with the limiting rights of the local government units regulating the use of streets, highways, right-of-ways. The Department shall report quarterly to the Legislative Research Commission beginning July 1st, 2003 through December 31st, 2004. The report shall be the detailed progress made in carrying out this section and the efficiency of regulatory programs implemented. Alright, definitions. Department means Department of Natural Resources. Commission means the Commissioner of the Department of Natural Resources with the Director. Director meaning with the Division of Oil Gas provided with the KRS 353-530. Commissions mean Kentucky Oil Gas Conservation Commission as providing KRS 353-566-65. Person means a natural person, corporation, association, partnership, or receiver of the governmental agency with subject. KRS 353 through 500 through 720, trustee with a so-called common law, statutory trust, guardian, executor, administrator, or fiduciary in any kind, federal agency, state agency, city commission, political subdivision, commonwealth, interstate body. Correlative rights means responsible opportunity for each person entitled to recover, receive without waste oil and gas in, under, and produce the tracts in which person owns and controls oil and interest or proceeds thereof. Oil means a natural crude, oil, petroleum, other hydrocarbons, regardless of the gravity in which produces well, liquid, and ordinary production methods of which are not result of the condensation of the gas after it leaves the underground reservoir. Gas means all natural gas, including casing, heading, gas, and all other hydrocarbons not defined in subsection 7 of this as oil. Pool means an underground reservoir containing common accumulation of oil or gas or both areas established by the Department of the Commission as a pool. Each productive zone and general structure with completely separated from any other zone of the structure which is purpose of 500 through 720 may be declared by the Department and covered by the word pool. Field means a general area which the unrelated appears unrelated. At least one pool field includes underground reservoir containing oil, gas, or both. The words field and pool mean the same. Field and pool mean the same thing, with only one underground reservoir involved. However, the field, unlike the pool, may relate to two or more pools. Just equitable share production means to each person an amount of oil and gas both substantially equal to the amount recovered oil and gas part of the oil underlying his or her tracts. Abandoned when used in connection with a well or a hole means a well or a hole which has never been used, which opinion with the Department will no longer be used for the production of oil and gas for injection or disposal of fluid therein. Workable bed means a coal bed usually being operated commercially. A coal bed the Department decides can be operated commercially with the operation being reasonable. Expected to commence within no more than 10 years. A coal bed which outcrop indications other definite evidence proves the Satisfaction Commission to be workable, which will be operated, will require protection wells drilled through it. Well, means a borehole, the proposed drill, the purpose of the producing gas or oil through with the gas or oil being produced. Drill process, drill for the purpose of injecting any water, gas, or other fluid into which the water and gas or other fluid is being injected. Our shallow well means any well drilled completed to the depth of 6,000 feet or less, except in this case of the well drilled completed to the east longitude 84 degrees 30 feet shall mean any well drilled with a completed depth of 6,000 feet or above the base of the lowest member of the deviant brown shale, whichever is deeper in the depth. Deep well means any well drilled completed below the depth of 6,000 feet, in this case the well located to the east of the longitude 84 degrees 30 feet with a drill with a completed with a depth below 6,000 feet or below the base lowest member of the deviant brown shale, whichever is deeper. Operator means for a deep well, an operator right to develop, operate, produce oil, gas from a pool, appropriate oil and gas produced therefore either himself or himself and others. In the event there's no oil or gas leak existence, with respect for the track of the question owner and oil gas rates there shall be considered royalty owner extent with the prevailing royalty in the oil gas portion underlying the tract owned by the owner as an operator remaining interest of such oil and gas. In the event oil is owned separately from the gas, the owner and the right to develop, the operate, produce substance being processed, produced, and sought out to be produced from the pool should be considered operator to such a pool. For the shallow well, any owner right to develop, operate, produce oil, gas from a pool, appropriate oil and gas therefrom, either with himself or herself, from him or herself and others. There's no oil and gas lease existence with respect to the track of the question owner and oil gas rights there shall be considered as an operator extent of 7/8, and oil and gas is the portion of the underlying the tract owned by the owner as the royalty owner 1/8 of the oil and gas. If the oil is separated from the gas owner and right to develop, the operator produce substance being produced ought to be produced for the pool is considered operated as the pool. Royalty owner means any owner of the oil and gas place with the gas rights extent with the owners and operative defined subsection 17 of this section. Drilling unit generally means a maximum area in a pool which may be drained efficiently, but one well as produce reasonable maximum oil, gas, reasonable recovery in the area. Regulatory authority has provided establishment drilling unit and an operator pursuant to the framework of the rules prescribed has taken the action necessary to specify the area established for the production well of the area being drilled. Underground source of drinking water means the subsurface waters identified with the regulation promulgated by the department, which shall be consistent with the definition of underground source of the drinking water regulations promulgated with the Environmental Protection Agency pursuant to Safe Drinking Water Act, Title 42, U.S. Standard Code 300F. The 10th sequence underground injection means any subsurface and emplacement of fluids. Well injection does not include the underground injection natural gas for purposes of the storage. 22. Endangerment underground source of the drinking water means underground injection may result with the presence of underground water which supply with can reasonably expect with the supply of the public water supply system. Any contaminant in presence of the contaminant may result with the system not complying with any natural primary drinking water regulation may otherwise adversely affect the health of the person. Class 2 wells means the inject fluids were brought with a surface connection. Conventional oil and natural gas production may be commingled with wastewaters from the gas plant integral with a part of the production operators unless those waters in classified hazardous waste time injection for enhanced recovery of oil and natural gas. Storage of hydrocarbon liquid standard temperature and pressure. Fluid means a material substance which moves whether in semi-solid liquid, sludge, gas, or any other form of state. Horizontal well means a well bore in which initially drilled on the vertical directional plane which is covered to become horizontally near horizontal in order to parallel a particular geological formation which may include multiple horizontal stacked laterals. Vertical well means a well bore in which the drill on a vertical or directional plane formation is not turned curved horizontally. Allow the well bore additional excess oil and gas reserve in the formation. Prevailing royalty means a royalty rate and percentage that the Department Commission determines a royalty most commonly applicable with regard to tracking unit issue with the royalty rate with the Department of the Commission should not be less than 1/8 or 12.5%. Best margin management places mean with a demonstrated practice intent with a control site runoff pollution, surface water, groundwater to prevent reduced pollution waters of the Commonwealth. Abandoned storage tank facility means an above-ground storage tank interconnected group of tanks no longer being actively used, maintained conjunction with production, storage, and crude oil produced water. Spill prevention control measure structures mean contaminant structures constructed around storage facility that contain facility discharge. Landowner means an owner and owns real property when abandoned storage tank facility is currently located. Chemical Abstract Service means a division of American Chemical Society that is globally recognized authority. Information Chemical Substance Chemical Abstract Service number means unique identification number assigned with a chemical abstract surface. Chemical means an element, chemical compound, mixture of elements or compounds that have only one own specific name and identity, such as chemical abstract service number. Chemical disclosure registry means the chemical registry known as the FRAC focus, developed by the Groundwater Protection Council and the Interstate Oil Gas Compact Commission. Any register become with a permanent inoperable chemical disclosure register shall be means of the other public accessible website designated by the Commissioner of the Division, Kentucky Division of Oil. Emergency spill discharge means an uncontrolled release or spill of discharge associated with the oil, gas, well production facility that has an immediate adverse impact, public health, safety, environment. It is declared by the Secretary of the Cabinet. Health professional means a physician, physician assistant, nurse practitioner, registered nurse, emergency medical technician licensed by Commonwealth of Kentucky. High volume fractional treatment means a stimulated treatment of horizontal well pressure to application more than 80,000 gallons of water chemical propellant combined with any stage of treatment under 320,000 gallons into the aggregated treatment with the initiate propagated fracture for the geological formation purpose, enhancing extraction, production, oil, and natural gas. Proponent means a sand or natural man-made material that is used in the hydrofracturing treatment to prop open and artificially created or enhance fracture once treatment is completed. Total water volume means the total quantity of the water all sources used in the high volume hydraulic fracturing. Trade secret means information concerning the volume of chemical relative concentration of chemicals used in the hydraulic fracturing treatment that is known only to the hydraulic fracturing treatment owner's employees, former employees, personal under contractual obligation to hold the information confidence. Has been perfected, appropriated exercise, and individual ingenuity give the hydraulic fracturing treatment's owners and operator obtain advantage owner over competitors who do not know the information is not required to disclose, otherwise made available to the public under federal, state law, and administrative regulation. Cabinet means energy and environmental cabinet. Stratigraphic text well means an exploratory borehole drill from the sole purpose of acquiring surface geological structure test data. Notice means the sending of a certified mail last known address for the day of delivery early with the date shown certified mail receipt within 30 days after the date shown on the postal service proof of the mailing. Purpose of 353, 620, 630, 640, and 700. Unknown noticeable ownership is deemed to have the received notice provided with the person given the notice has called for the published no more than 30 days from the submission of the application order to issue the application one notice in newspapers largest circulation in each county in which any tract of the portion of the effective of the proposed to be effective is located. The applicant should provide a copy published notification of the director with the 20 days of the date of the publication and note. Notice shall A. state with the applicable application being filed with the division and the order being issued pursuant to the application filed with the division describing any tract portion effective of the proposed to be effective. In this case, unknown owner identified name of the last known owner. In this case, non-locatable owner identified by the owner and owner's last known address. State with any party claiming an interest of any tract with a portion thereof effective proposed to effect shall contact the operator and publish the direct. Control person means a person who has the ability to commit financial real property assets of the working resource of the debt and to comply with this chapter of the administrative regulation promulgated to hereunder with respect to the operation well and the manner in which well is operated. Has any other relation with the give of the person authority with the determined manner of the wells operated plug the band includes reputable the presumption that ineligible person directing action of his or her spouse child files an application offers for the director general partner of the entity has an ownership of the interest of the entity equaling exceeding 50%, except that the cabinet may be determined that the person has controlling interest of the entity less than 50% of the ownership unless the person is determined qualified in paragraph A of this section of the control person does not include the independent third party service company, contract operator, well tender, and pumper owner, and non-operated undivided working interest limited partner, a unit holder, limited liability company, or any other person with a virtue of joint operating agreement with a governance agreement or other contract relation that does not have the right to control over the manner and well is operated with a plug and abandoned. 47. An eligible well means an orphan well, an abandoned well that possesses imminent threat of the human health and safety of the environment. Orphan well means any oil or gas well defined in subsection 14, the section that has been determined by the cabinet improperly abandoned, improperly closed, has no known owner operated well, continuing legal responsibility. All owners and operators continue with legal responsibility for the well determined to be financially insolvent following reasonable investigation conducted by the cabinet. Alright, territorial application of KRS 353-500 through 720, waste and oil gas prohibited shall apply with all lands located in the Commonwealth, however, the owned with included any lands owned and administered by the government and agency, political subdivision thereof, over which the Commonwealth has jurisdiction under its police power. Waste and oil gas is hereby prohibited. Waste prohibited ends with the physical waste of the term generally understood for the oil and gas industry include locating, drilling, equipment, operating, producing any of the oil gas well with wells drilled deep in the reopening in a manner that causes tended to cover the reduction of quantity of oil gas ultimately recovered from the pool and prudent and proper operation contrary to any of the provision, any other rule, regulation promulgated by the KRS 353, 500, 720, prohibiting migration oil, gas, and water stratum in which it found with the other strata, ultimately resulting in loss for recovery of the oil and gas or both, drowning with water any stratum on the part of the air capable of producing oil and gas paying quantities except for the secondary recovery purposes and hydraulic fracturing of other completing practices, unreasonable to damage underground fresh or mineral water supply, workable coal seams of the mineral deposit operation for the discovery, development, production, handling of oil and gas, even unnecessary excessive loss of oil and gas by spillage, venting, the destruction of oil and gas are constituted with the drilling more well with the responsible required to recover sufficient maximum amount with the oil and gas for the pool, production of oil and gas, any of the well, any of the pool, unless permit has been issued with the required in 350 through 720 with the violation spacing from 500 to 720 prohibited except for the subsection shall not prohibit the continuation production of oil and gas from the well producing oil and gas in June 16, 1960. Alright, Director of Division, Oil and Gas Qualification Duties and Oath. The Secretary of the Energy and Environmental Cabinet shall appoint with the Director of the Division, Oil and Gas of the Department of Natural Resources the person that has, every time of the appointment, at least 5 years experience with the exploration of the production of oil and gas. It shall be his due with the administrative of the 353, 500 through 720, subject with the direction and supervision of the Commissioner before taking off of the Director shall take an oath, which shall be certified with the Office of the Administrator of the Office of the writing with a certificate shall filed with the Office of the Secretary with the date. No Director shall, within holding office, acquire the financial interest directly, indirectly, any venture activity, exploration for the production of oil and gas in this Commonwealth. $540. Authority of the Department of Jurisdiction of the Department authorized shall be with the duty of the Administrator of the KRS 500 through 720. All rules, regulation promulgated in orders here under the conduct of the investigation of the deemed necessary of the Department is hereby granted the authority to jurisdiction over all person and property necessary for such purpose. Specific authority over oil and gas operators without limiting general authority of the department shall have a specific authority to require of and from all operators of oil and gas property with the Commonwealth identification, producing, leave the submitted form of the production required by the department and reported, making drill logs, filling all the logs down holes over the made with the drilling casing operation, plugging wells in such manner to prevent the escape of the oil and gas oil one pool within mineral bearing strata, detrimental intrusion of the water, oil and gas pool and mineral bearing strata avoidable by efficient operation blowouts, caving and seepage fires, filling on the report plastic department transmitted with the Kentucky Geological Survey that prescribed the rules regulation promulgated here under all such reports shall be shall be transmitted by the Department of Kentucky Geological Survey within 30 days of the receipt thereof by the department. Further authority, without limiting general authority, the department shall regulate with the drill plugging all wells, spacing, locating of the wells, with the vacuum, and the department shall take with the recommendation U.S. Environmental Protection Agency, Energy and Environment Cabinet as disposal of salt water and oil field waste. 353, 561, determination of abandoned storage tank facility restorative and preventive actions. Purpose of the section of the KRS 562, 563, and 564. Storage of the tank facility not being actively used if the maintained shall be deemed abandoned if the cabinet sends the written notice by certified mail return receipt with a request for the address last known operative the operative of the facility with the tank over the registered agent of the corporate owner and operative with the owner and operator fail with the response 30 days after the receipt of the notice and indicate with the intent of the continue with the tank of the facility within 30 days of the owner and operator indication of the intent of the continue with the use of the tank facility owner and operator show with the task of the tank facility active with maintenance implement spill prevention control countermeasure plan after 30 days of the operator indicating with the intent to continue with the tank of the facility with the operator fail to restore the status of the facility to use the active maintenance countermeasure of the deem of the tank of the facility abandoned. Alright, Kentucky Abandoned Storage Tank Orphan Well Reclamation Program. Kentucky Abandoned Storage Tank Orphan Well Reclamation Fund. Use funds received with the Federal Infrastructure Investment Jobs Act. Initial grant types. This is hereby, there is hereby with the grave of the Kentucky abandoned storage tank with the orphan well reclamation program. And the purpose of this is to remediate, reclaim the abandoned storage tank with the properly plug and abandon with the eligible well to address imminent threats of the human health, safety, environmental pose of the oil and gas facility located within the Commonwealth Reclamation abandoned storage tank facility. Eligible wells of the program shall include the removing the necessary well tank infrastructure with the proper plugging and abandonment of the eligible wells, properly abandonment of the tank with the posing of the imminent threat of the human health and safety environment, implementing best management practice with the sites of the eligible wells being the storage tank facility with the removal of the primary secondary source of the contamination, land, oil, air, and water. Orphan wells abandoned storage tank facility determined with the cabinet eligible plugging with the removal of the reclamation cleanup fund of the Kentucky abandoned storage tank orphan well with the reclamation should be addressed in accordance with section 353, 561, 563, and 564. Conduct the abandoned storage tank orphan well reclamation fund hereby created the interest-bearing restricted agency account. Fund should be administered by the cabinet interested creditor of the account will be retained within this account, notwithstanding 45.22.9. Any monies remaining in the fund close of the fiscal year that not lapse shall be carried forward with the succeeding fiscal year with the use for the purpose to authorize and set forth in 353, 561, 563, and 564. Funds established in Section 2 sections may utilize expendable funds authorized by an annual budget. Monies in the funds shall be carrying out the purpose provided in subsection 1, including administrative of the costs incurred with the cabinet during the implementation. Section 50, 561, 563, and 564. Fund may receive the money federal, state, and grant with the operations and from any other receive of the purposes of this section. 561, 563, and 564. Separate accounts may be established with funds segregate monies received with the extent of the offer different programs operated with the Kentucky abandoned storage tank and the orphan well reclamation program. 5A. Funds may be expended with the costs incurred in the remediation, reclamation, abandoned storage tanks, and proper plugging, remediation, reclamation, abandoned eligible wells, proper remediation, reclamation, abandoning of the storage tank facility posing imminent threat. These funds be expended in accordance with the section after the cabinet determines who well qualifies eligible with the wells for the defined in 353, 510. There is no person identified found with a continuing legal responsibility abandoned storage tank facility. Reclamation remedial measures are necessary to respond to the imminent threat of the human health and safety environment posed with abandoned storage tank facility and proper abandoned well. Reclamation measure of the pay for the fund shall include the following: removal of the disposal of the abandoned storage tank facility with the reclamation lands affected the abandoned storage tank facility included, proper removal of the abandonment flow lines, removal of the treatment of contaminated soil with no more than 3 feet in the depth, the elimination of all berms and dikes out of the structure, utilize the spill prevention control measure structure, creating stabilization, seating of the surface where the tank and the tank battery was located, implementing best management practice sites associated with the abandoned storage facility, reclamation lands affected with the eligible wells, proper removal of the abandonment flow lines, removal of the disposal of the surface of production equipment, grading stabilization, seating of the surface of the well that was located, implementing best management practice sites associated with the eligible wells, removal of the treatment that contains soil with no more than 3 feet in depth, if and during the course of removing and reclaiming abandoned shore of the tank with the facility plugging or reclaiming the eligible well, the division observes evidence soil contaminant below 3 feet of depth of the division, consult with the Department of Environmental Protection, determine whether the function, further actions necessary to protect the public health of the environment. Nothing contained in this section construe, but they obligate the fund to provide additional money for the removal of the treatment of contaminated soil other than subsection 6B2 and C5 of this section. Any person performing reclamation measures for the pursuant of this section shall comply with the applicable local, state, and federal law. Regulation cabinet shall have the authority to contract services provided with the engage with the cooperative projects other than government agency, private with the furtherance of the remedial reclamation project authorized undertaken pursuant to sections 561, 563, and 564, and enter into agreements with the government agency, private parties to compensate the agency of the private parties for the funds of the account, with the disposition of the separate account for the fund in federal, state, with the other funds proposed subsection 10 of section 561, 563, and 564. Monies received by the Commonwealth from Infrastructure Investment Jobs Act, Public Law number 11758. Shall be placed in separate account with the fund of the Ministry of the Award contract with the committee with the issue for the purpose of the Public Law 11758. When the federal guidance for the issue of the pursuing of the monies received by the Commonwealth, the Public Law 11758, when they may be used in plugging with abandonment wealth of the remediation, reclamation, associated pipeline facility, and infrastructure with the eligible funding within this section. shall be maintained with expanded with the manual that provided any of the federal rules guidance for the issue of the pursuant of the Public Law 11758, except for the notification allowed with the initial grant subsection 12 this number the eligible well with the vendor scope of the contract for the issue pursuant with subsection 10 of the section all of the grants issued within the Public Law 11758 limited to 1/3 of the contracts in a 12-month period with no limited to no more than 10 wells, 1/3 of the contracts in a 12-month period shall be limited to no more than 25 wells, 1/3 of the remaining contracts issued within a 12-month period shall have not a limit on the number of wells and scope of the work. The cabinet may adjust the number of the wells bid package issued with the pursuant subsection 10 and 11 in the section of the needed in order to comply with the deadlines issued over the Public Law and the 117 F8 with the initial grant with the provide with the overall percentage required in subsection 11 section achieved at the end of each 12-month period. As used in section grant types, meaning the initial formula performance grant category states that apply for the money to clean the orphan well that was described in December 17, 2021. Guidance for the states issued for the United States Department of the Interior. Alright, 353-563 cabinets for the entry of the property to removal of the reclamation, abandoned storage, fangs, facility, and properly abandoned well. The cabinet authorized representative of the agent of the contractor shall have the right to the authority to enter the improperly thrown with the abandoned storage tank facility with the improperly abandoned well for the access to any other property. For the purpose of the plugging and the reclaiming the improperly abandoned well for the removal of the reclamation, abandoned storage tank facility, the cabinet makes the determination for the abandoned storage tank facility for the improperly abandoned well purpose of the imminent threat of the human health and safety of the environment over the 353-562 5B3 for the action should be taken from the public interest of the abandoned storage tank facility properly plugged and abandoned with the well to reclaim the land stripe and the abandoned storage tank facility as well. Owner and owners of the property are not known and are not readily available. The owner and owners will not give the command and permission from the Commonwealth of the public subdivision to the employee of the contractor for the upon the property prior to entering the land for the purpose of the conducting plug with the remediation operation of the cabinet shall give the notice of the mail for all the ownership of the property for the known and the owners for the unknown of the property. Cabinet shall post notice of the upon the premise of the advertise with the once of the new paper in the general circulation of the municipality or the county and land which well of the abandoned store of the tank facility is located. Advertisements shall occur at least 7 days forever to enter unless existent circumstance for the existing necessity of the cabinet's agent for the employees of the contractors enter the upon property as soon as possible in order to mitigate and prevent imminent threat of the human health and safety of the environment. In addition, with the cabinet authorized representative, the agent contractor shall have the right to enter upon the property for the conducting field with an inspection investigation to determine the existence status, eligible wells, abandoned storage tank facilities, and feasibility plugging remediation removal of reclamation eligibility well with abandoned storage tank facility. Enter upon land under the subsection construed in the exercise of the Commonwealth Police Power for the protection, public health, and safety, general welfare, interest should not contribute to any of the condemnation of the property trespass thereon. Further, the cabinet may initiate additional any other remedy for the KRS Chapter 353, any court of the component jurisdiction, any of the action, equity, for the injunction, restraint, for the inference, for the exercise of the right to enter of the two, for the conduct of work authorized under 353, 650, 561, 562, and 564. Any person in the tent room of the abandoned storage tank facility shall the notice of the cabinet undertake with the removal to do his or her own risk expense, be sole responsible to comply with all applicable local and state and federal law regulations during the removal of the disposal of the reclamation of the site. Nothing in this section can contribute additional grant with the authority for any person entry of the cabinet agents taken under the section 353, 561, 562, and 564. Alright, 353, 564, when an owner or prior owner deemed to have waived certain right of the cabinet's authority to recover actual and necessary expense within cover the implementing 561 through 564 cabinet personal hours to seek within cost efficiency public benefit administrative the regulation. Any prior ownership of the owner shall be deemed to have the waive of the right with equipment to provide product remaining in the site of the orphan well with abandoned storage tank facility with the time plug and the removal of the reclamation cabinet with the contractors pursuant to section 561, 562, or 563 because of the abandonment and neglect of the facility with the being plugged, removal of the reclaim of the public amenities of the Kentucky abandoned storage tank with the orphan well with the reclamation 562 pursuant to paragraph A subsection cabinet agents include with the plugging and removal of the reclamation remediation contractor all equipment and products removed with the orphan well with the abandonment of the storage tank facility sale of the recycling disposal of the cabinet shall have the authority to recover actual and necessary expenses that include the administrative of the cost reasonably incurred with the carrying out of the duties section of 561, 562, 563. Last owner and operator record, abandoned storage tank facility which funds or money is expended, any other legally responsible cause and contributing to the threat of the human health and safety of the environment of the Commonwealth incurred as a cost and expense under Section 353, 561, 562, 563. Cabinet may initiate an action when the reimbursement costs any of the cursed component jurisdiction recovering any of the cost section of the 353, 563 issue with the credit of the Kentucky Abandoned Storage Tank Orphan World Reclamation Fund, except for the recovered administrative costs which should be retained by the Cabinet. The Cabinet may not seek the reimbursement landowner costs incurred under this section unless the landowner qualifies the last owner or operator under Section 2A of this section and caused by a contributor to the threat under Section 2B of this section. Expenditures of money defined with the purpose of the KRS 353, 562, 5, and 6 prior to its filing order. Eligible wealth of abandoned storage tank facilities are imminent with the threat of the human health and safety of the environment. Abandoned storage tanks, facility, orphan wells could pose the threat of the human health and safety of the environment. Evidence, proximity structures, streams, river, water bodies, other sensitive areas, and abandoned storage tank facility, orphan wells that could pose potential threat of the human health and safety of the environment. The Cabinet may address the abandoned storage tank facility with the eligible well, regardless of the priority. If doing so will cost efficient, otherwise create with a demonstrable benefit of the public large. Cabinet promulgated the administrative of the regulations pursuant to the KRS Chapter 313A in order to provide further detail related to ranking wells, abandoned storage tank facility, plugging, removal of remediation, reclamation. Alright, then we're going to read Kentucky Oil Gas Conservation Fund, and we're going to cut the tape there.